Hello, good afternoon and welcome to this 13 Essex Chambers Planning, Environment and Property Group webinar on practical tips on compulsory purchase or compulsory acquisition and compensation. My name, in this slightly croaky voice, is Richard Harwood, and I'm joined by two of my colleagues from Chambers today, Celina Colquhoun and Jonathan Darby. Juan Lopez, who was also joining us, is not well today. He's managed to do his slides, which I will talk to a little bit towards the end of the session, but unfortunately isn't in good enough form to join us. So thank you very much for joining us. I know that many of you will have been booked onto the original date, which we'd set for January for this webinar. That got sort of overrun by inquiry dates being pushed about and various colleagues not being available on that. So we thought what we'd better do is to rearrange, which we've done, and so glad to be here. I hope everyone has survived the storms fairly well. It's not looking too bad where I am at the moment, although our basketball hoop got knocked over on Wednesday, landed on its front. It's looking a bit squashed, so I think if the children use a rugby ball, we should be okay with it now. And the Chambers social WhatsApp group spent most of Friday being filled with photographs of trees having come down on things. Made the change from the kittens, but hopefully we won't have too much more of that. So I hope you are somewhere safe, somewhere comfortable, and if you're not at home, are able to get back okay, given all the disruption that's taking place. So we're going to sort of move on with the session. A few things to let you know. There is a Q&A button at the bottom. Please put any questions you've got, and what we'll do is pick those up towards the end of the session. The webinar is being recorded and it'll be put up within the next day or so along with the slides. And for the recording, we're going to be using live transcription on that. So not only is that sort of helpful for anyone who's got hearing difficulties, but also does give the opportunity of watching it with the sound down, which might be seen as an improvement, but never know. So with those sort of intros, and we'll be finishing by 4, pass over to Celina to get us started.
Thank you very much, Richard. So, oops, for some reason, oh, it is working. I think there's a little bit of delay on my end. So this is very much practical tips on CPO as we headed up this seminar. But I know that there are wide experiences with those who are attending, and it's quite difficult to know how best to pitch it. But you have a team of us here who have been involved with CPO through DCOs and other matters. And so if you have further questions, for example, I'm not going to be dealing with purchase of common land or special category land, crown land, or allotments and field gardens and things like that. But if you wanted to ask questions about that, please do. Also, if you wanted to raise questions about temporary use or subsoil, those are other factors that I've had to deal with fairly recently, and it's an interesting topic. But anyway, putting that aside, just a small bit of background on me. I've probably been dealing with CPO for about 10 years, although before that I dealt with my CPO education was through highways orders, which I did quite a few through promoting orders for the highways agency as it was then. But it was in fact this time 10 years ago that I was being led by Ian Dove when he was Ian Dove QC, and we had the pleasure of promoting the Manchester City Academy. Yes, I do know they lost the weekend, but I do still have my Etihad hard hat somewhere. I'm afraid I couldn't find it in time for this meeting. But anyway, the joys of CPO, it's a very interesting topic. Indeed, if you've had to deal with it, and when it goes wrong, that is a depiction of what one can feel. Nobody likes to come second, and the purpose of my chat will be to make sure we don't end up feeling like that. In terms of a refused CPO, so where you have done everything you can do as an acquiring authority, but in fact the CPO gets refused, then you must challenge by way of judicial review. And the thing to note about that is that it's 3 months from the decision, not the 6 weeks. Although there is a question over whether a CPO that's been promoted under section 226 of the Town and Country Planning Act, which I'll mention a bit later, is formally 6 weeks. So if in doubt, far better to stick to the 6 week period rather than push it for 3 months. And the powers that the court has in relation to that judicial review is as to be expected. It would be that the decision itself is quashed and the court can remit the matter for inquiry. Again, very familiar from planning matters. There was a case where saying that very thing happened, which was, I don't know whether any of you remember, but it was a Southwark case that dealt with the Aylesbury estate, and the matter was dealt with by consent and indeed was remitted, and now there is a CPO in place. If your CPO is confirmed and you have been an unhappy objector or person aggrieved, then the basis for your challenge would be sections 23 and 24. Now, any person aggrieved can be wider than simply the person who objected or has a right to be served the CPO decision itself. But the bottom line is that there would need to be some considerable degree of prejudice shown if you were to show that you were a person aggrieved. You know, the language I've set out there of section 23 is questioning the validity of any provision. And then I'll come on to deal with section 24 in a moment. And again, the period for challenge is 6 weeks, and there is no discretion to alter that. It is in effect an ouster clause like 228. The grounds for challenge are, again, I've just set them all out there. The language is not empowered to be granted, but it was made clear that by Sullivan Mr. Justice Sullivan, as he was then rather, in the case of Powell, that basically what one is looking for, what the court is looking for, is any procedural or legal error in familiar judicial review terms, and indeed that there must be some level of material considerations have been failed to be considered, or inadequate reasons, or procedural unfairness. And I've set out a few cases there that I'll come back to in a moment. And section 24(2) also makes it clear that there has to be substantial prejudice from the applicant. Now, the reason that I'm dealing with things this way round, I hope will be clear, is because it is the need to be paranoid, to be frank, and that one should be able to prepare or else object or make representations in CPOs, knowing what it is that ultimately will need to be overcome if you are going to be challenged, or if you want to mount a challenge. And that's why I've started from this way round. The examples I've put of inadequate reasons in Gibbs, whilst it's an older case, it was in the 80s, that the complaint there was that the inspector had simply not dealt with the objector's case in any proper way, and therefore was unable to understand why it is that his objection had not been upheld. The case of Harada again was where again it was it was simply not possible to understand why the inspector had taken the position that he had. And in terms of procedural fairness, I've highlighted Grafton, which was an interesting case because the wife of who was a joint owner of the property had not been served and had not been able formally through her own interest to object to the order, but her husband, the co-owner, had. And she sought to challenge the made CPO, the confirmed CPO, but it was held that her interests had not been prejudiced. In terms of Hibernia, what had happened in this case was that the inspector had gone out on the site visit after the inquiry and had spoken to residents about various matters, but not in the presence of the objector. So not really a CPO special, but it indicates that needing to be careful about procedure will ensure that CPO may fail. And lastly, material considerations, just like planning considerations, alternative sites are a relevant consideration. Brown was a gypsy issue where there were alternative sites and the inspector was held to be wrong to discount the suitability of those alternative sites as a consideration, and upheld a case of Rose which deals with it from a planning perspective. Another material consideration was not a typical cost issue, but it was related to whether there was a need in effect for this CPO, because what was being asked for was to acquire the site, then demolish everything and rebuild, whereas what was being put forward, it was much cheaper to simply repair, and that was deemed to be a material consideration that should have been taken into account. So out of the storm of the challenge that you might expect, we would turn to the sea of tranquility of Tatooine, and hopefully confirm that we can show you that this is the way. In terms of where we start, this is the way we'll begin with the Acquisition of Land Act. That sets out the basic authorisation procedures and will apply to, as you will know, most compulsory purchases. And where it doesn't apply, the processes and justifications will be extremely familiar and similar. So, for example, compulsory acquisition, as it's called under the Planning Act 2008, is, as we know, is part of the one-stop shop process, where you deal with compulsory acquisition next to, in effect, permission for the development itself, combined with any other orders and statutory processes that may be required and are dealt with under that process. Indeed, it is actually a month ago that we've had the Aquin decision, where we'd been, both Christian Zwart and I had been representing objectors to the Aquin DCO. So it was a decision that had been delayed, and there's now been, the order's been refused, and we're waiting to see whether there will be any challenge. But that in particular looked at alternatives to compulsory acquisition, as well as whether the inspector had properly dealt with associated development and other associated issues, which dealt with justifying that compulsory acquisition. So watch this space, but alternatives do seem to be slightly flavour of the month, as I put it to my clients. And I'll come back to that in a little bit. And I've just also added in that where other acts allow for compulsory acquisition, that will be dealt with through separate procedures through Parliament, but I'm not going to look at those today. There is a lot of, I think, very helpful guidance out there for those who are having to come back to or to deal with CPO for the first time. The Critchell Down, well, they always used to be known as the Critchell Down rules, but the CPO guidance, which has now been updated in 2019, it's very, very similar to that which was some 10, 15 years old. And it does provide some extremely helpful step-by-step processes, although some of the language I come to is a bit odd. There is also an online guide, which is specifically for the layman, but is, again, just helpful to read through. It's more helpful perhaps in terms of what it's directing in terms of compensation and business and agriculture and residential owners or occupiers, and how they should approach acquiring authorities, and highlighting, if you know about a CPO, the process that may be happening, this is what to do. But guide 1, which is a separate little guide, looks at procedure, and again, it's just worth reading. There is also a brief guide for Transport and Works Act orders. That again is extremely good practice tips. It's 2013, but it's still helpful to this day. And there is a lot of guidance on DCOs, and I don't want to tread on Jonathan Darby's territory, and he will come back to this as well, but the CPO guidance in that, again, is extremely helpful, and there are some very familiar passages in that overlap with the other CPO guidance. Now, the first thing to do, if you're thinking about CPOing, or if you're thinking about whether a local or an acquiring authority has got it wrong, is to make sure that the Enabling Act is the right one. The Local Government Act has broad powers, and Section 121 deals with the grants in effect the powers to principal councils. Now, you may be surprised as to who a principal council includes. It does include Metropolitan Police, and indeed Richard Harwood and Christian Zwart and myself and Richard Wald were all involved in a CPO case that again was decided about a month ago. Richard and Christian were advising Metropolitan Police, and Richard Wald and I were looking at, were representing the objectors. And indeed, well, so keep quiet about it, but the CPO was refused, but we shall wait and see what happens next. However, the principal act that was relied upon was both the Local Government Act and various other police acts. Section 125 is an interesting power. It relates to where local authorities can take CPO action on behalf of parish councils. So it's worth always remembering the Local Government Act, just for if you're trying to look to decide which power you should go under. And that applies also when you're looking at the Town and Country Planning Act, because Section 226 is the big one for that, and I'll come back to that in a moment. But it's important that you choose properly between the Local Government Act and the Town and Country Planning Act, or you might be able to combine, but the advice is very clear, is to choose the most specific enabling powers. Housing Act 1985, Section 17 is the principal provision for that, and that deals with where you've got vacant houses and you have the vacant property policy within a local authority, and I've promoted a number of orders for that back in the 90s or early 2000s. And Local Government Housing Act, that also deals with housing, as you may expect, Education Act, so that's for local education authorities. It doesn't deal with academies, that's dealt with under a separate matter. Highways Act, again, I'll come back to that in a moment, but there are a number of powers, as you all know, under the Highways Act that deals with improvement and construction. The relevant sections that deal with CPO are what are used when highways are not either covered through the DCO limitations, but also where local highway authorities are the ones who are doing the promoting if it's not a strategic road network. Listed Building Act, I'm sorry, I haven't set out the full act, that also has CPO powers, enabling powers, and Homes England itself has powers under the Housing and Generation Act for housing and regeneration. So let's quickly look at section 226 of the Town and Country Planning Act. It's described as a positive tool to help local planning authorities, and it does in particular refer to the Assembly of Land, and again in particular refers to the fact that this is about implementing proposals in the local plan or where strong planning justifications arise. It is described as a general power, but it is divided into two. And it is made quite clear in the guidance that you should choose one or the other. Section 2261 small a relates to the carrying out of development or redevelopment or improvement or in relation to land. And that relates to specifically to where you need planning permission. It does also specifically require that those promoting the CPO on that behalf need to show 3 well-being objectives, and that's 2261 capital A. By contrast, 1B is phrased in effect as where it's necessary to achieve in the interests of the proper planning of an area. And it has been the source of some debate because the CPO guidance interprets this section to be intended primarily to acquire land which is not required for development, redevelopment, etc., or as part of such a scheme. But the planning encyclopedia that reference makes the point that is actually altering what the meaning of the words. I in the past have understood it to mean it's kind of anything that's not 2261A, but I have never been part of a CPO process that has used 2261B, and it may be that that's something that we need to look at, but for the most part it is a question of looking at a development that is coming forward for planning permission or has already got it, and land is required to support and then implement that planning application. Not forgetting 2263, which allows for the compulsory purchase of land required for executing works for facilitating development. So it's kind of adjacent land that's additional, but again must be justified on the same basis. There are overlaps with the Highways Act under the Town and Country Planning Act. So clearly the stopping up or diversion orders can be dealt with under section 247, and that's related to a development. But if you need power, if you need land to support those stopping up or diversion orders, then that's under section 254. We come to the Highways Act. The principal sections that I've dealt with, I've dealt with fairly recently, is sections 239, 240, and through to 246. And the scheme I'm thinking of was the Hereford Strategic Link Road, which we did actually get. We did get the order allowed, confirmed rather, but politics took over. And also I dealt with a local highway improvement scheme down in Gloucester, and I'll come back to some of the issues that arose out of that in terms of where you want to acquire land, again, that's needed for construction, but may in effect be only a temporary requirement. But there is no power under the Highways Act to acquire temporarily, and temporary use only arises under the DCO still at the moment. Section 246 is the one where most debate arises. Again, this is where you want to acquire land for the purposes of mitigating any effect, and refers to blighted land. The question sometimes arises is, again, this is part of the sort of pre-order process, is whether you ought to, given the potential impacts that the highway scheme has or might have on a landowner, that you consider purchasing by agreement, and that's under section 246, and this is a very important part. So here is the paranoid list, and in fact I was pleased to see that Jonathan also kind of does deal with the same points, which is that, remember from the very beginning that it has to be a compelling case in the public interest in order to get through the confirming authorities inspection. You also clearly have to note that there are human rights interferences and how that is dealt with, but that is also, it is accepted, it's part of that compelling case process, but you do need to recognise that it's a separate consideration. CPO should always be a matter of last resort, and that is connected to how the extent to which an acquiring authority has gone to try to avoid CPO, and that includes by negotiation. Again, I'll come to that in a minute. It is imperative that you get your statutory procedures correct. There are some examples where lesser procedures were followed. Grafton was one of the examples, but if in the early stages, if you fail to carry out your if you fail to notify, and if you fail to properly identify a landowner, etc., that is a pretty fundamental issue. Don't forget that the Equality Act, the SED needs to be met, and that's also, there's some useful guidance again in the CPO guidance, paragraph 6, and it is also going to be imperative that an acquiring authority shows that the land is actually required and it is actually necessary for the underlying scheme, and the test, legal test is set out in a case called Sharkey. So, prior to making your CPO, what do you do? Well, the very obvious thing is identify your land and make sure, absolutely sure that you actually need it, and to establish what those rights that exist on that land are, and under the section 172 of the HAPA 2016, you have powers as an acquiring authority to enter and value land at that prior stage. Once you have carried out that sort of process, then you need to start going into the referencing stage and making again sure that you have identified all the relevant and qualifying persons, in other words, tenants, owners, occupiers, and I would say licensees as well as ordinary occupiers, but that obviously that's an overlap, and I would suggest, even if it is a very short license or very short tenancy in effect, it is far better to have identified that person. The third thing, of course, is to ensure that the process itself can be funded, and you will have to demonstrate, you as an acquiring authority will have to demonstrate that to the confirming authority. And that includes not only the underlying scheme, if there is one, so under 226, that the development can actually be built, So that's part of this, avoiding any impediments to the CPO, but also that there is sufficient funding for the relevant compensation and any blight that might arise as a consequence, especially if you are taking a while to establish the land that you need or the underlying scheme. So if there's a long planning permission stage and you want to ensure your planning permission is in place beforehand, there will indeed be blight, or there may well be blight as arising out of a local plan allocation. So those are matters to take into account. The big thing, negotiation. Now, the newer guidance was notable because it used the words set out on that slide, which is that an acquiring authority is expected to provide evidence that meaningful attempts at negotiation have been pursued, or at least genuinely attempted, say for lands where land ownership is not known. So that should be taken to heart by any acquiring authority, and indeed somebody who may have been missed in the negotiation process, because that is something that is a level of evidence and a level of requirement that an acquiring authority will need to show, and it has to be meaningful. Public consultation, it is a matter for the acquiring authority. There are no set statutory rules. I mean, it is potentially similar to DCO, where there is a long lead. There's no requirement to put an application in after one specific public consultation. You can carry out as many public consultations as you like, but it is an important part of the process and allows for public engagement. You may well need to get your planning permission in place. The resolutions are needed to take any CPO forward, both in terms of principle and a resolution to make the order, and the forms of the orders are set out in the 2004 regs there. Do not omit the notice requirements, so formal publication and service on each of the qualifying persons, and there is a period within which the objector must object, 21 days. So general form of the CPO, I won't take too much of your time on that, just keeping in mind the time. What is in terms of a usual format, you begin with your powers and you will attach a schedule which identifies the land and rights in bigger orders. So for example, highways orders and or DCOs, there will be a book of reference, and it will be not a formal book, but it looks like a book. And you will need to have identified each of the interests and each of the rights and each of the plots. The plots should be set out on these specific plans showing each plot, and indeed the colour of the right that you are acquiring has a format. So pink for freehold ownerships, etc. The last thing, the statement of reasons, this is not a statutory requirement, but it is one that is always accompanies a CPO and should accompany a CPO. I haven't come across a position where a CPO will be held to have been in breach because there is no statement of reasons, but it is an extremely helpful document. It should be as comprehensive as possible, and it forms the basis later for a statement of case that will be required for prior to confirmation or prior to submission to the confirming authority. Now, objectors. So there is often a debate not with who is a relevant objector or a remaining objector, but whether third parties in effect can object to CPOs. And the tendency in my experience is that because ultimately, if the decision is to be made by way of a public local inquiry, people who are not necessarily objectors in the strict term may attend. and it is up to the inspector who will be running the inquiry as to whether those objectors are able to be heard. It is a matter of practice with highways orders, again, because given usually they're dealing with relatively public schemes, as it were. So members of the public may well be affected by the underlying scheme, whilst they may have had a chance or may have the chance to object to any planning permission that's required. Highways inspectors will tend to allow the public who don't have specific interests to come and make their points. Anything that they do say, however, that is not about the justification of the CPO itself, but is more to do with why they don't like the scheme, or if they consider that that the scheme itself shouldn't be justified and it's not really an issue dealing with the CPO, then that is something that an inspector may well disregard, and anybody promoting such orders will make that point, or should make that point. If there are remaining objectors, and that is only a remaining relevant objector, and they've not withdrawn their objection, then the matter must be dealt with under section 13A, and objections overall must be made in writing, as I said before. How is your order to be confirmed? Well, usually the confirming authority is the relevant Secretary of State. If there are no relevant objections, or all of the relevant objections have been withdrawn, and what is left is just maybe disregarded, then the matter will simply go to the Secretary of State and may be dealt with under section 13A by written reps, or by if there's no relevant objections and everybody's been withdrawn, then the matter will simply go to the Secretary of State. But the confirming authority must consider whether all of the matters have actually been addressed. So you can't just get a tick in the box. There has to be consideration of the statutory requirements. If there are remaining objectors, it is possible under section 13A for the CPO to be considered under written reps, but again, that has to be agreement by the objector and the inquiring authority, or there is a public local inquiry or a hearing, and the inspector may either report or now may be appointed under section 14D to consider and confirm the CPO himself, or may report to the confirming authority. And lastly, it is possible for an acquiring authority themselves, if again there has been no objection at all, and there's no requirement for any modification or compliance issue, then the acquiring authority themselves can become the confirming authority. I have made it. Thank you very much for listening. And now let's turn to Jonathan.
Thanks, Celina. Hopefully everyone can see and hear me. It'll be a rather short presentation if I'm just speaking to myself for the next 10 minutes or so. I'm going to try and pick up from Celina's kind of framework that she's identified. And there's a little bit of crossover with regards to things like justification. But the emphasis of my presentation is hopefully going to be on some of the practical experiences and lessons that we've learned over the past few years in promoting a number of orders. Could I have the next slide, please, Celina? So the other aspect of my focus is going to be with reference to kind of fairly large scale infrastructure projects, partly because some of these practical lessons are to be learned tenfold in respect of those projects, simply because they're often land hungry. So with road network improvements, HS2 is another example, clearly there are considerable acquisition needs in order to deliver those projects. So many of the challenges that you face on a much smaller scale with other projects and other orders are multiplied or felt with far greater force. Clearly, this sort of project also requires the use of compulsory purchase order powers or similar consenting regimes in order to acquire the swathe of land and rights that you need for construction, operation and maintenance. And those type of projects, typically linear projects, will often have a greater impact on a larger number of landowners across a much wider area than more traditional, for example, regeneration schemes. And what that does is, yes, it gives rise to considerable challenges, but it also, I think, gives rise to the opportunity to learn from lessons earlier along the line or further down in order to be applied further down the tracks, as it were. Next slide, please. So Celina touched on a range of ways that we might look to, or enabling powers. This slide just touches upon the breadth of and I've broadly called them consenting regimes, but the breadth of ways in which these sorts of issues and these sorts of aspects of practical learning arise in respect of these projects. And many of these points can be read across all of these regimes, even if the formal labelling for each of those steps might be slightly different. Next slide, please, Celina. And what I've said here is, to emphasise that point, really, there are a number of common themes, and I've tried to distill what follows into those 5 subheadings. So justification, which Celina touched on, and I'll try and embellish upon a little bit shortly. Preparation of the orders, engagement with stakeholders, negotiation, and the presentation generally on behalf of acquiring authorities. So if we look at justification first of all, which is on the next slide, it's worth remembering, it's a slightly obvious point, I suppose, in some respects, but it's the acquiring authority that needs to decide how best to justify its proposal under any particular act. The acquiring authority will need to be ready to defend the proposal at any inquiry or through written reps and, if necessary, in the court. So one can note from that quotation that it's not a short process, but it's quite clear that you need to make sure your house is in order from the very start, and that any engagement that you undertake is undertaken on a consistent basis, and likewise with regards to negotiations. It's important that if you say something is going to be done, that you ensure that it is done, but also that if you say that something is being done for a particular reason, that that reason has been sense checked long before it's aired in public. So if we look at the next slide, we can go into this in a little bit more detail. And these are some of the points that Celina touched upon. But clearly, in order to justify compulsory acquisition, we need to have a clear idea of how the land to be acquired is to be used. It's no good simply speculatively including land or rights within an order. They're going to be scrutinised in great depth, particularly if one gets to an inquiry stage. We also need to demonstrate that you've got all the necessary resources within a reasonable time scale, and that needs to cover the process itself, acquisition, but also implementation of the scheme. So make sure, for example, there's not a black hole in your figures because you haven't included costs of compensation, for example. You'll also need to demonstrate that the scheme is unlikely to be blocked by physical or legal impediments. So you need to be able to show that your programming of the works takes into account those consenting regimes, the need for planning permission, whether there's other licensing regimes that might apply to the operational phase, that those are all likely to fall into line in due course. And if you haven't got them, and planning permission falls into this category as well, if you haven't got it at that stage, because it's not necessarily essential to demonstrate you've got it at the point you make your order, you need to show that there are no obvious reasons why it may be withheld. And something that comes up, and it came up in a project that I was working on 18 months, 2 years ago, was where a planning permission had lapsed. And then it was all about going back and making sure that we could demonstrate and present a persuasive argument that nothing materially had changed in the intervening period, so that it was highly likely that, having been granted in the past, it was going to be granted in fairly short order, despite what the objectors may have had the inspector believe. So if we could go on to the next slide, please. This then looks at a statement of reasons. I'll just wait, I think I've got a slight lag on the slides. There we go. Sorry if I'm a lot further behind than everyone else. There'll be a few pauses while my screen catches up. But with the statement of reasons, that's setting out the advanced case for making the order, but it's also explaining why certain powers are sought. It's also an opportunity to set the scene. Why is the land being taken, but also why is the project essential? And in my view, the approach to that document should be strongly evidence-based in order to demonstrate the compelling case in the public interest that you're going to have to defend if you get to the inquiry. This is your first opportunity as an authority, not only to set out what you've done previously, but also why all of that prior work has led you to this point and the making of this particular order in respect of this particular project. So the next slide then looks at preparation. And clearly some of these things run in parallel to a certain extent. But as Celina's highlighted, there are certain key documents that need to be prepared, the order and the schedule being prime among those. And they need to detail the powers that are requested, interests and what have you. But some of the more practical points, I think, follow in the next bullet points. And in preparing to make the order and in preparing to engage with stakeholders and to negotiate with landowners, I think it's key to ensure that you've got an effective governance structure. You need to know and have set out what your hierarchy of approvals is so that you know clearly who's doing what, but also how you get the mandate in order to sign certain things off. For example, and it might be something as straightforward as sealing of a particular order. What day does that take place on? Who do you need to go and see to ensure that it's done on time? If you've promised to a stakeholder that a commitment, for example, will be embodied in writing by a certain date, who do you need to go and speak to ensure that that's done and that that promise is lived up to? Again, put in place an experienced professional team. And my advice, my strong advice in many of these scenarios is to do that as soon as you can, really, at a much earlier stage than perhaps one might otherwise expect, simply because it allows those professionals, whether they're surveyors or whoever it is that you want to have working on your behalf, to ensure that they can lay the paper trail that they might at a later stage be required to defend in evidence. It's far easier for those professionals to defend their own working than it is to be parachuted in a month or two in advance of an inquiry and trying to piece together, particularly on these big projects where negotiations might have taken place over the course of a number of years and record keeping might have some gaps and what have you. It's important to make sure that from the outset that everyone's got an eye on the fact that you might be at an inquiry poring over a footnote to a meeting minute from 2.5 years ago. So be mindful of that, and as I say, try and put in place an experienced team as early as is reasonably possible. Be clear within that team also as to who's responsible for what. If you've got certain people conducting certain negotiations with certain landowners over a particular portion of a route, but others conducting negotiations with landowners over another portion of that route, how are those professionals speaking to one another? How are the lessons being learned, being communicated to one another? How is the authority as a whole presenting a consistent picture and a consistent voice at those during those negotiations, so that if at a later stage you have remaining objectors and there's a need to air certain aspects of laundry in public at an inquiry, making sure that there's no embarrassing inconsistencies between the manner in which you've dealt with particular objectors. Clearly, there may well be good reasons for dealing with different objectors differently, but if there aren't and there isn't a justification for doing so, I think it's important to set out the rules of the game and the rules of engagement as early as possible, and to ensure that they're promoted as consistently within the acquiring authority and throughout its engagement with others as possible. And there are numerous examples of that. It doesn't have to be just kind of institutional learning. in terms of how you work out what's gone well and what challenges you face, but it can be learning through the project lifespan itself, but it can also be by reference to other projects. Crossrail, for example, has enabled those working on HS2 to rely upon or to have learned a considerable number of lessons from what is a fairly similar project with a number of fairly similar challenges. So if there are resources available in respect of other projects, don't be afraid to refer to them internally as part of that learning process. Next slide, please, Celina. Thanks. That's it. So it's about, I think all of this is about understanding, managing and mitigating risks. So trying to identify what's going to be risky, trying to design out problems, extend notice periods where that might be relevant. But all of it needs to be done with proper records being kept and a paper trail that's laid with a view to an inquiry, but also always related directly to a well-articulated public need that can be communicated consistently, but also a project that's designed directly to meet that need, as well as any supportive planning policy. And through that project lifespan and through the lifespan of this order, the making of the order and seeking its confirmation, there's nothing wrong with testing the extent of your proposed acquisition against that public need, and do so, I would say, certainly at each design stage, but don't be fearful of doing it at other intermediate stages as well. And likewise, don't be fearful of doing so at a very late stage as well, because far better to accept or to acknowledge that the land take, for example, is too great, even at inquiry, and seek modifications yourself, than to leave an order unmodified and potentially at risk of non-confirmation. So be mindful of the fact that there is a need for flexibility, because no matter how closely you scrutinise things, there will be things that arise as you go through it, or you might get witnesses on board who look at it slightly differently from a construction perspective, for example, who can say, actually, in the 2 years since the order was made, we've learned how to use a different type of tunnel boring machine that would mean we need to have a smaller launching pad or something similar along those lines. But don't close your mind to those possibilities, because, as I say, it's far better to present them as a lesson learned and to control the way that issue comes out, than, for example, for it to come out during cross-examination of your witness, with your wider team having never considered the repercussions of that. And really that next bullet point about assessing those requirements for different design options is going to that same point. Make sure you're doing so on a consistent basis over time. So don't look at those different design options that ultimately generate a completely different output, if actually that output is what's formed the basis of your compelling case in the public, compelling case for the justification of the order. So be careful that you're testing those options consistently over time. In terms of managing and mitigating risks as well, identify politically charged acquisitions, as well as acquisitions that could affect the programme, for example, sensitive buildings. Pick those up, highlight those, make sure that you've attributed sufficient resources to those issues to ensure that they're dealt with properly, and engagement is done on the correct basis with regards to them, with an eye on the prize or the longer time horizon wherever possible. Next slide is about engagement, and I've included a slightly dated reference there, but I think it captures what I'd like to say about engagement, and that's that it's not just, there's a tendency, I think, at times to look at engagement as a necessary step, but not necessarily a helpful step. It's something that people look at slightly fearfully. Whereas I think actually it offers opportunities, as I say, opportunities for flexibility, opportunities to test alternatives, opportunities to design out risks. But it also offers other people within a project team, senior managers, for example, that are referenced in the quote here, to ensure that they're on top of evolving objectives, interests, constraints, and expectations, but also to sense check those throughout that lifespan as to whether or not they're reasonable, whether or not those objections are being properly made and sustained, or whether they're simply, for example, points of compensation that actually are for the tribunal rather than for an inspectorate inquiry. What I've tried to do on the next slide is to summarise what I think from past experience are some of the key fundamentals of that practical engagement. Because the importance of all of this, I think, comes down to, or can be summarised with reference to, well, if you as an acquiring authority meaningfully engage, and that you can evidence that you have done so and taken steps to help an affected party to mitigate impacts, then the practical upshot of that is it lowers the hurdle that you need to surmount in respect of demonstrating the public need, or rather that the public need exceeds a lower mitigated private loss, because you'll reduce objections, you'll increase the chance of dealing with objectors, but it also, through your engagement programme, helps to establish firm foundations for a constructive relationship. And that might seem a little bit odd to try and to frame it in that way rather than the more typical adversarial context. But I think it's important, particularly for these large scale projects, particularly for those that are going to take a great many years to deliver on the ground, but are going to require multiple meetings between usually very similar, a very similar cast sheet of individuals. If that relationship gets off on the wrong foot, then the whole thing is going to face considerable challenges. But all of this equally, I think it's important because you show a willingness to listen and an openness to alternatives, but it also, I think, is important to recognise when there are some affected parties who don't want to sell, because the type of engagement that you're going to undertake with those affected parties, I think, is going to necessarily be very different to those that are willing to sell, relocate, try and get an early deal to ensure that, for example, their business is disrupted to the least extent possible. But the reason that engagement for those two different sets of affected parties is so important is because you can seriously undermine your relationship with an affected person if you keep going back and banging on the door and talking only about acquisition, whereas actually that affected person has set out their stall very early on that it's not for them, or rather acquisition by agreement simply isn't going to happen because they want to substantiate or try and present a case in objection to the wider principles of the order itself. So explain the impact of the project, and the benefit of that is because you can give claimants a sense of control. For example, something I touched upon a minute ago in passing, if you allow them a full and proper understanding of timeframes, for example, they can plan their relocation, they can know when possession might be required, they can know notice periods, and that gives them some degree of certainty, both in respect of their operations or their livelihoods or their homes, but it also gives them hopefully some kind of certainty as to compensation. So be mindful of the fact that you need to frame your engagement with people differently, depending on the interest or the nature of their responses and the nature of their likely objection to the order. The biggest problem in respect to that first kind of header about understanding the impact of the project is the fact that with many of these big projects, particular details about the project design are not necessarily sufficiently mature at that initial engagement stage. And during that time leading up to inquiry, for example, things become more definitive. But as they become more definitive, so do the impacts of the projects on affected parties. And a good example of that could be construction methodologies, where you might get a design of a project that is sufficiently fleshed out at the early stages to get you through the EIA and planning permission stage, but it doesn't necessarily tell someone how many cranes are going to be on an adjacent plot for how many months, or how long their land might be needed for, whether or not it actually goes beyond what's reasonable for a temporary acquisition and into something that's required more permanently, until you've actually procured the main contractor. So yes, there needs to be a certain degree of caution in terms of the way, the manner in which the breadth that you apply to drawing up the order, but it also gives rise to some challenges with regards to engaging about the impacts of the project. That's also relevant if you're going to mandate people to give commitments, because if you're going to give commitments, that can considerably impact your design and construction. It can inhibit the scope of options that contractors might be provided with in terms of the way that they might want to deliver that contract. It might increase costs and it might impact on project viability. So be mindful of that. And when giving commitments, make sure that you understand the need to retain flexibility for future evolution of design, of detailed design and construction methodologies. Don't bind your contractors' hands too tightly if that is going to give rise to considerable challenges in terms of costs, for example. Understanding where affected persons and parties are coming from is critical, because that all claimants are effectively under a duty to mitigate their loss, and that means in essence that they should take all the steps that a reasonable person would take to minimise the cost of their claim. But that doesn't mean that they need to go above and beyond that. They don't need to take unreasonable risks. So, for example, a small business wouldn't necessarily be expected to make a commitment to buy another expensive property before the acquiring authority had committed to pay compensation. But in that sort of example, something that you could do through understanding or a careful understanding of the financial consequences to that business, something that an acquiring authority might do is to facilitate the early purchase of an alternative premises, because that might enable a mitigation of a material impact, and it might allow that claimant to avoid losses that will ensure from the acquiring authority's perspective that compensation is kept within budget. So understanding it can only come through meaningful engagement rather than lip service and box ticking. Working together, and this really leads on from the last point, working together to mitigate the impact. So early engagement isn't necessarily all about getting lost in the details, but it's about getting sufficient clarity, both communicate in terms of communication about the project, its aims, objectives, its impacts, but also so that the acquiring authority can make its own assessment of risks and costs, and then make a decision, which is often a very difficult decision, between what, and if any, mitigation funding is actually value for money, and that which that authority is willing or able to provide, because all of that has to be bound up in a risk assessment in terms of, well, are we going to go to inquiry? What are the costs of taking it to that stage rather than dealing with it or addressing that now? How does that impact upon any likely compensation claim? And I think part of that engagement process is making sure that the reporting back from those meetings is sufficiently clear, accurate and thorough enough so that those risks can properly be understood and tracked over time, so that that informed decision, which might be a different decision at a later stage, is still necessarily or nevertheless a good decision. The final point is about relationships, and it really is an overarching theme, particularly again for these big projects, because although you don't necessarily have a willing seller in the negotiation process, and often don't, that doesn't mean that it all has to be adversarial. Even if you can't immediately agree terms, make sure that there's a relationship there that can be built and that trust can be built in order to try to work collaboratively. That trust needs to be earned and is easily lost. And something I said very early on, I think to one of the second or third slides, was about avoiding over-promising. So if you are making commitments, if you're going to say you're going to do something by a certain date, make sure you live up to those promises. But equally, make sure that you manage expectations from the outset. Something that some of the schemes I've worked on, some of the bigger projects that I've helped to work on, have done is to set out clearly and in writing the kind of rules of the game, as it were. So what the acquiring authority is looking to achieve in its engagement, so whether that's compliance with guidance, whether it's identifying opportunities for mitigation of loss, whether it's effective limitations of funding. So it's about testing the water, but then setting it down into a clear structure, which I think actually often, although it's front loading the thing, actually saves a lot of time and cost in the long run. And for the big schemes, publishing clear acquisition policies. So how will you deal with fees before and after powers are confirmed, for example, I think is pretty essential actually, because it allows that consistency of dealing across the board with various different affected parties. So that, a rather lengthy nutshell, is how I see the importance of engagement. And it blurs onto the next slide, which is about negotiation. And as everyone, well, lots of you will be familiar with, there's not necessarily the case that negotiation comes at the very end, and that's the point made on the final bullet on that slide. Look, if you know that this is going to be a long time in gestation, there's nothing wrong with undertaking negotiations in parallel with preparing and making the order. There's nothing wrong, indeed, it's expected that you're going to be taking reasonable steps to acquire the land by agreement. So lots of these things are going to run in parallel. You might have negotiations running in parallel with your engagement process, but I think it's important that there's some degree of institutional oversight of all of those strands, pulling threads and strands, invented a new word, the institutional oversight of all of those threads, pulling together lessons being learned from engagement, feeding them through to your negotiators, so that prime amongst all of those risks doesn't materialize, which is that you don't end up with a handful of interests that still remain to be acquired despite years of negotiation, because those last remaining objectors frequently are the most difficult, but they are also frequently the most expensive. So trying to make sure that your negotiations are conducted in a timely fashion, but they're done so on a meaningful basis, and that you keep an accurate record, so that if you've done those steps and you've got your ducks in a row, if you've got a remaining objector saying, well, there wasn't an attempt to acquire our land properly by agreement, you can say, well, hang on, to an inspector, hang on, here's reams of records that demonstrate that we've engaged from the very outset, making reasonable offers, and despite all of that, actually, we've got someone still objecting. But that objection doesn't really go to the principle of the order. It really is a point of compensation that ought to be addressed elsewhere. And that's where you want to try to get to. Ideally, you get rid of everyone through negotiation, but frequently you won't be able to. But don't necessarily draw stumps, even if you're at inquiry, because there's a number of occasions recently where I've certainly had objectors withdraw their objection at the very 11th hour. So don't give up just yet. They might just need to see how weak their evidence is or how strong your case is before you crack that nut. So the last slide, I think, in my presentation is handily titled presentation. These 3 bullet points are prime, or are my summary of what we've just been talking about. And actually, I thought this morning when I looked at them again, they can be read across to objectors as well. So those of you who are here and looking at this from an objector's perspective, I think that these 3 bullet points apply equally to you. Demonstrating a willingness to listen, so engaging on a meaningful basis. Being flexible and open to alternatives, again, equally applicable to authority and objector. And establishing firm foundations for constructive relationships. Don't be blind to the opportunities that can be presented through meaningful and constructive discussions with people on the other side of the room, because as I conclude there, successful delivery of these projects generally comes down to being proactive about risk, opportunities, but also stakeholder management. So that's me done. So I'll pass over to Richard, who's going to, for 20 minutes at least, be Juan Lopez, I think.
Jonathan, thank you. And yes, picking up Juan's baton, and what we'll also do is take time for questions. A fair number of questions have come in. Please do send some more in if you want us to pick those up. But what I'll do is I'll take this through relatively quickly, there are quite a few practical tips. If there are things which I've not picked up, or I've got a different angle, I think, from what Juan was looking at, then please do drop him an email if there are any queries that come. But let's sort of start with the footnote, start with the terms and conditions to the presentation. Looking at the approach to compensation and leaving aside planning assumptions. That's of course the assumptions that planning permission will be granted, or what you secure on a certificate of appropriate alternative development as would be granted for that scheme. It's important, I think, on big schemes to remember that the assumption about what planning permission will be granted on the site is not necessarily going to be reflected in the valuation world. So it may be that the compensation process will say, yes, you could get planning permission for this big residential development on the site. But if the site you're dealing with is a bit of countryside in the middle of nowhere, or it's some rather rough bits of East London prior to the Olympics, the valuation of that is going to be very different. You wouldn't assume that necessarily that a planning scheme would actually occur. And there's plenty of old cases, mainly involving Basingstoke and the Town Development Act, where that difference is explained by the courts. Now, moving on to the slides from the points from the outset, I think what's important to have in mind in advising clients, I think on both sides, is to be realistic. The nature of a compensation claim is that unless there's something very unusual going on, the person who's been dispossessed is entitled to some compensation. It's a matter of working out how to get to that figure and trying to do that as smoothly as possible. And that does require, to my mind, both sides to be realistic. From the claimant's perspective, this isn't an opportunity for a windfall. It's a matter of trying to recover what your loss really is. And from the acquiring authority's perspective, whilst you don't want to be spending public money when you don't have to, do bear in mind that if you've taken land off somebody, it's going to cost them, and that should be properly dealt with and reflected. What's also, I think, important is that try and get to grips on both sides with what the issues really are, what's going on, what the assumptions are, because my experience, I'm sure it's one's experience, and I suspect probably most barristers who deal with these things, that quite often you get brought into a compensation dispute years after acquisition, when correspondence has been going on for 2 or 3 or 4 years, and a client has finally had enough and is thinking about going to the Lands Chamber. And quite often they're sort of sitting there wondering, why on earth has it taken so long to get not very far? And we're an awful long way away from each other. And often it becomes the Lands Chamber procedure, the evidence coming in and so on, which starts getting the parties to a point where it's possible to agree. Now, we really very much hope that that's not going to be the situation very often. If we move on slides from the outset ones, and onto counterfactual. So look particularly aimed, I think, this slide at claimants, but looking through the situations, chronology is where you're at, what the business is doing, what the landowner is doing at a particular time, and the importance of the third bullet point of recording what your expenses are, what your relocation costs are, what are your spending management time on. I mean, those sorts of things are all claimable, often claimable in that sense without too much difficulty, provided you documented it. And if a business is looking at a loss of profits claim, then those are actually very difficult to demonstrate. If you're having to relocate, saying, well, you moved, we've lost a lot of disruption doing that, we've lost some of our customers and so on. Be thinking whilst it's going on, what is actually happening to the business and why, and how that is attributable to the extent it is to the CPO process. Okay, next please. Appropriate valuation methodology is important because when you're looking, the primary question tends to be, what's the market value of the land? Answering that, I think it does go to the question, well, how in realistic terms does the market value it? If this property in the use it's currently in, or a use which it could be put in, was being put on the market, how would a purchaser decide how to bid? How would a seller decide what the appropriate price was? Usually the preference from the Lands Chamber is to look at the comparables, sort of other sales, ideally around that time, before that time, what's influencing the market, and to make adjustments. Now, some situations that may be relatively straightforward, a pretty conventional house that's being acquired, or a commercial unit when there's plenty of commercial units unaffected by the scheme who are being bought and sold in the locality. In some situations that may be very much more difficult, either because the whole locality is affected by the scheme, involved like from housing clearance and like, or perhaps it's a fairly unusual form of use that's involved and the number of comparables are very frequent, and they are some quite difference away, but the comparables are the best thing to be working from. The residual land valuation approach, the classic sort of development appraisal exercise, can be done. It's got some major problems. One is that if you're looking at a development potential of a site, you've got the question of assumptions of what that alternative scheme is, how that all gets costed, how the assumptions work. And of course, as we know from looking at those sorts of valuations, two things. One is that it doesn't take a lot to dramatically change the residual land value in the assumptions which we're making as part of an overall project. And secondly, is often quite a legitimate degree of skepticism about the accuracy of a lot of those things. I think the third point is that that's the question, would the market have actually done that exercise? If not, it's probably not the best way of trying to value the compensation. And then look at, if it comes to it, other ways in which the market will genuinely try and value that type of asset. Okay, next please. Very short point. Think the potential permutations in the arguments. What's the alternative? What direction might the tribunal go down? And make sure that the evidential basis is there and the valuation methodology is there if that's a proper secondary position. Because if the tribunal does go down a particular route, maybe the other side's route, it may be a third way that comes forward. It's not a lot that the tribunal can really do without the evidence and without the expert opinion in mind. Next, please. Shunfang Ironworks, Privy Council case from Hong Kong, which set out a lovely principle that the owner should be paid no more or no less than their loss. And that's the element of the losses that are caused in the shadow of compulsory acquisition, bearing in mind that that may well have held back what's going on. It's a kind principle because it's one, I think, to have in mind always when you're looking at the various complexities and immense complexities sometimes of compensation, which is to go back to, when you're doing that, is that actually what the loss to the owner is? And if you're dragging your analysis one side or other of what that loss looks like it is, then something's probably gone wrong on that. But it's a less useful principle in this respect, that it's not a principle of law. It's not, I'm afraid, a situation where compensation is decided by a single sentence in legislation saying the owner should be paid no more or no less than their loss. It can't be applied as such as a method of working up the compensation. We have to work through all the processes to get to that, and if that ends up looking like it's a departure, then ultimately so be it, albeit that they ought not to do so. Can we move on, please? So, starting point, principal rules in Section 5 of the Land Compensation Act 1961. The key one usually is Rule 2, that you value the land by its open market valuation, assuming you have a willing seller and a willing buyer. And that's disregarding the scheme. So disregarding the compulsory acquisition, disregarding what's led up to it, a particularly important situation if a site is blighted by development, disregarding the benefits which might accrue from the scheme for those particular purposes, and not getting a ransom which wasn't already there otherwise. There are fewer principles worth bearing in mind, and lawful or unauthorised uses will be discounted from that. There may be situations where the local authority will then want to regularise, or at least get enforcement notices in place to spell out what those are, and a few situations where reinstatement value is payable, usually involving churches, things that don't actually have, while they're important land use and important land needs, don't actually have in itself much land value, but where that particular body needs to find somewhere else it can move to. Okay, next slide, please. The valuation date is set out in the legislation, and that's an important principle, particularly in situations where the land values are moving relatively quickly, possibly also in situations where the values are moving in different directions, but essentially it's the date on which the owner is dispossessed, or if it's done in advance, an earlier date. Next one, please. A couple of common elements reflected there. We want to move on to the question of the no scheme in this regard, and really just sort of point out where the provisions are, which is set out in Gordon's next couple of slides. Before we do that, injurious affection, which is when part of your land is lost, and ransom value to have in mind. Yes, but it has to be the value that's inherent in the land, and often difficulty is working out whether there is actually a ransom value in circumstances where acquisition under compulsory powers is being used. Starting off there, but okay, next one, please. The no scheme world, that is the notion which it comes to valuation, you, I say, disregard the effects of the scheme. Point good, slightly unusual situation where there's a big port scheme being organised, being required, and what was being disregarded was the increase in the value of the quarry. And the fact if it hadn't been CPO'd, it could be used to serve the production of materials for the construction of the port. So a situation where the scheme itself was being relied on improperly in those circumstances to try and increase the value of the land. But often the situation is where you're trying to work out what would have taken place on the land if you didn't have the scheme, and that involves working out what the scheme is about, what's underlying that, working out what other things would come forward potentially with statutory powers, and also what's capable of coming forward without statutory powers in the assumption that the scheme doesn't actually proceed. And if we move on to the next slide, there is the more specific provision for dealing with disregard of new towns, urban development corporations and mayoral development corporations. That somebody can't say, well, if this scheme could have, the new town could be built up next to me, and so my site would have been incredibly valued because I could then put housing on it. That reflects actually the point I was making right at the start about the Basingstoke cases and the like. If we move on to the next slide, general qualification, particularly qualifications about transport projects and the way in which they may increase the value of land. So look at those if we're dealing with CPO related to those projects. And then I think, well, maybe the final slide. Not one, bit more transport projects. And then I think the next one, please. Thoughts on disturbance. Summer disturbance is relatively straightforward if it's properly documented. What is the cost of selling your house and the transaction costs involved in moving somewhere else? More difficult is dealing with business-related disturbance. That will, in terms of a shape relocation, that's the easy bit. The loss of profit element is far harder to gauge, and my experience is it does require very cogent evidence to demonstrate loss of profit where a business has been forced to relocate but has continued to trade. Particularly in situations where the business, of course, is going to be peddling like fury to try and keep its business up, develop new markets and the like. So, I mean, realism and contemporaneous evidence is going to be critical. The final point to make there is to look very carefully at the situation of business tenancies. Normal assumption will be if you have a tenancy, then the landowner will terminate that as quickly as they can, and so bag more of the compensation if that's the way of doing it. But those situations will vary depending on the type of tenancies. So that's what I wanted to send the presentation. What we'll do is we'll open ourselves back up. Jonathan and Celina will join us. Conscious of the time, if anybody does need to slip off, feel free. But we'll pick up, I think, fairly quickly, run through a variety of, I would say, extremely good questions, which we've been getting during the course of the session. So, Celina, do you want to pick up I think there's a second question that's come through the list about difficulty getting statutory undertakers on board to fit in with a time limit for schemes? If you're promoting, John may give some views as well, if you're promoting, how do you get the statutory undertakers to respond? You're on mute. I always do that.
Oh yeah. The good question. How do you make? I mean, there is trying to get them on board is a question of, is a matter simply of negotiation. The bottom line is there's no power to compel a statutory undertaker to do anything. It really depends upon what sort of scheme you're talking about. But my experience from trying to get, for example, Network Rail to respond quickly to almost anything is quite hard. It is easier if you have, if you're dealing with your own highway authority, or if you're dealing with other statutory undertakers whose kit is within any of the land that you're trying to deal with. They are not going to want to leave matters until, well, you'd like to think until the last minute. But as with a reluctant landowner objector, if they fail to engage, then you are left with a position where you're going to have to put it in front of an inspector. But the main thing is to have an eye on that test that shows that you have meaningfully engaged, and all the points that John has made about making sure that you that you can show that you have tried to engage properly. But I sympathise if you have had difficulties trying to get statutory undertakings to respond. I don't know whether anybody else has had better experiences.
Yeah. Okay, John, we've got questions coming about how the acquiring authority deals with property that's sort of registered to a deceased owner, or where you've got a joint owner who's deceased and the survivor and children are still in the property. Any thoughts?
A nice and straightforward one. I think it probably boils down to two things really. The first one is kind of the prior step, or the step that arises prior to the question coming about, which is about referencing really. It's kind of making sure that your process is, I think the phrase is diligent and reasonable, and inquiries and the like, making sure that you're thorough enough to identify those nasty instances where you might have a joint owner that's deceased and others that are dealing with the estate. But in terms of formal steps, trying to deal with those difficult circumstances, I think the closest I can think of as an example was a scheme that I was helping to promote where it was just a deceased owner, and it was rather like the first example. So you've got a deceased owner, but it was occupied by others. And what we ended up doing as the acquiring authority there was jumping through numerous hoops in terms of demonstrating that you have tried to engage and tried to convince them to go through the stages of probate. Because if they're not able to deal with the property, then there's very little else that you can do with them that's of relevance. So it's doing things like writing to them, engaging them, trying to encourage them to go through probate, but equally affixing notices to the property addressed to the owners, addressed to the occupiers, because ultimately you've got to have in mind who are these people and are they qualifying interests or qualifying persons. So, and if they're not, then their importance is significantly diluted. And if they are, then you're going to have to engage with them and deal with them appropriately.
Okay. All right, no questions come in, which I'll pick up about how land can be acquired for a parish council compulsorily for a cemetery. Parish council is a burial authority, and so the provisions in the Local Government Act 1972 apply, and the district council is able to acquire the land for the parish council under section 125. So that would be the power to use within the 1972 Act. And whip through another question. I'll gain a chance to talk quickly about the prescribed form regulations, about the length for which they get, and forms 10, 11 on sort of the confirmation or making by the Secretary of State of an order require notice to be served in a way which identifies all the land parcels being acquired, and that is, as our questioner points out, I think sometimes an extremely lengthy notice. So what notice do you need to put in the press in terms of to use within that? I think it's probably a bit shorter as long as it's descriptive, but as I think is pointed out, the Form 7, the form that publicise the making of the order in the first place, requires a description, albeit that it can be quite a long description that's involved. But we'll give that a little bit more thought, and we'll come back to the questioner on that one in due course. Another sort of question sort of bowled in is on section 203 of the Housing and Planning Act, which is the provision for overriding interest. When does that, any thoughts as to when that gets engaged?
John and I had a conversation offline. I think the wording of section 203 shows that the land needs to have been, the CPO land that needs to have been vested. So it is very much kind of that test, as opposed to what, you know, simply having the power to vest. I think but it is the successor to 237. So anything that I know the wording is slightly different between 203 and 237, but if there is any law on that, based on the guidance on that, on the 237 power, but the way that I've read the statutory provision is that it you know, the land has to have been already in your power, as it were.
Yeah, it ties it back. I think it ties it back, doesn't it, to the reason for the original acquisition or appropriation or vesting. So I think it's as a logical kind of next step as opposed to a prior step.
Okay, a few other questions have come in, but useful comment from someone at Network Rail saying if there are problems, then do really get in touch with them. They have internal clearance processes which consult the various departments, but that those do run on strict timetable and time scales. I
take it all back. I take it all back.
And Grant, who hopefully join us, has there's a lot of work with Network Rail on various things. So he'll have been sort of snapping away. But I think it's always a challenge for statutory undertakers dealing with the multiple requests they get. And I think the need, of course, is for clarity as to what is being sought. That's important always for acquiring authorities to understand what the issues are for the potential objectors, whether that's a statutory undertaker or it's a landowner who's got a business. Right, comment coming in about early identification is key, and I think what we'll do is, given and I have lots of very good questions, we'll have a look through the questions which we've had, and if there are points we haven't picked up, what we will do is drop the questioner an email. If there are any questions which you've got for either Jonathan, Celina, myself, or Guan, as what he would have said, please do drop us an email. Our email addresses are either on the slides, if they're not, they're pretty easily guessable, or on the Chambers website. We'll be sending out the presentation later on, so we'll have the slides, and it'll also be up on our website along with the recording with the closed caption up, so people can watch it on the train and the like. But thank you very much for joining us. I hope it's been a useful session. I think we've all enjoyed that, taking a break from slightly odd weather as well, and we look forward to seeing people, particularly in person, as the year comes on. But from me, thank you very much.
Thank you very much, everybody. Thank you, Richard.